Welcome and thank you for joining us for today's webinar, President Biden's COVID-19 Vaccination Action Plan, What Employers Need to Know. I am Karen Livingston, ABC National Senior Director of Policy, and I will be your moderator for today's webinar. Today's presentation is being recorded and will last approximately 60 minutes. This presentation will be available on ABC's website within 24 business hours. Attendees will also receive an email with a link to the presentation and webinar recording. Please note, all participant lines are muted. You are welcome to submit questions throughout the webinar by using the question box located at the bottom of the sidebar. We will get to as many questions as possible during the presentation. You may also minimize and expand the Go-To Webinar sidebar by clicking on the red arrow in the top left corner. Before I introduce our panelists, I would like to thank our strategic partners for sponsoring today's webinar. CNN, The Contractors Plan, JLG, Milwaukee Tool, Southwire, Tradesman International, and United Rentals. I would now like to introduce our panelists. Maury Baskin serves as ABC's General Counsel and is a shareholder in the Washington, D.C. office of Littler Mendelson, where he chairs Littler's Construction Practice Group and co-chairs Littler's Workplace Policy Institute. He is one of the chief legal advocates for the rights of employers on labor issues throughout the country, representing ABC and its member firms at every level of government, up to and including the U.S. Supreme Court. Brad Hammock is a shareholder in the Tysons Corner, Virginia office of Littler Mendelson. He works closely with employers to help them understand and implement safety and health management systems. In addition, Brad represents employers throughout OSHA rulemaking proceedings, including OSHA's informal public hearings on proposed rules. He also defends employers against OSHA enforcement actions. Please help me welcome Maury and Brad. Thank you, Maury and Brad, for being here today for today's important webinar.
Okay, thank you, Karen. Welcome, everyone. I see we have a pretty sizable crowd, which is understandable because you're being hit with stuff that's, if it feels like this has never happened before, it's because it's never happened before. We're seeing mandates in multiple directions. In fact, when the idea for this webinar first came up, we were talking about private mandates. A lot of construction users were starting to impose them in certain situations, but that issue has now been overtaken by the federal government mandates, and we're going to talk some about the states too. But the primary driver of this is the president's action plan that came out earlier this month, and we want to cover two very different angles to this, which could affect, each of which could affect a lot of you, some overlap, some none. We're going to try to get to it all. And when this first hit, many of you started asking, what's ABC going to do about it, or what is ABC's position on it? So we want to start there, but I do want to emphasize at the start, we have two separate rules we're going to be talking about. So you're going to get two for the price of one webinar here, and we're going to get you in on the timetables. In fact, I see we have a question already about the integration of the rules into existing federal contracts. We're going to talk about that. New contracts, when is it all going to happen, who's covered, and all the unanswered questions. Because one thing about this is they just did this almost seemingly on the spur of the moment, and now they're playing catch up and frankly assaulting all of you as well as us with trying to figure out exactly what they mean, how broad is this, and what's involved. So with that said, let's move ahead to want to get ABC's position out there off the bat, because we have a lot of cross currents here. You know, we have some people, some members, contractors, construction users who said, well, I was going to do this on my own. I'm glad the government's taken the burden off of me. We've had a lot, probably more, I think it's fair to say, contacting us, and by us I mean include the staff as well as us at Littler, talking about the burdens that are going to be imposed. What do we do if all our employees quit or the unvaccinated ones? How are we supposed to fulfill our government contracts? This could be really harmful. Or this OSHA thing, which is going beyond government contracts. How do we deal with all of that? And what is ABC going to do about it? And what is ABC's position on it? So ABC put out a news release on the 24th, right when the this new guidance on the government contracts came out. And this is basically what it says. This is a summary of ABC's position. You can read the news release at abc.org. The bottom line is ABC does encourage construction industry, the members, employees, to get vaccinated. That's been the position. But ABC's opposed to federal mandates in general, and in particular, mandates on businesses that undermine the desired outcomes. So there is concern that the federal contractor mandate is going to result in new burdens on construction contractors, going to make the skilled workforce shortage even greater because workers indicate they're going to resign rather than be vaccinated. And if that happens, then you're going to lose skilled workers. It's going to increase the cost for federal contractors and taxpayers. And that's just the federal contractor mandate. So we're going to be going through two rules. As I said, the first one is only a mandate on federal contractors, regardless of size. So that's the first one that we're going to talk about. That's the one where guidance has been issued just in the past week. And so that's the most immediate one. But the even broader one is the OSHA emergency temporary standard that the president has directed OSHA to come up with, has not yet issued, not expected for some weeks yet, but there's all kinds of talk about what's going to be in it. And that applies regardless of any contracts you have. It applies based on the number of employees you have, if you have 100 or more employees. So how you count to 100 and all these other issues that come up with OSHA, that's what Brad Hammock is going to talk about in the second part of our program. And we're also going to cover the action steps that ABC has been taking, but I will say here that ABC has expressed its concerns to the Biden administration and is evaluating all legal and compliance options for both rules. So let's and I see from a question that we're getting some echo. Hopefully our technology folks can deal with that. Okay, let's turn to how we got to this point with regard to the different things that the president has adopted. And by the way, the slides will be available after the program. So first, it's all really started on September 9th. And when the president announced this path out of the pandemic action plan, and it outlined both a federal contractor mandate, federal employee mandate, as well as the OSHA temporary standard and an executive order issued on September 9th. So all aimed at more mandates dealing with the vaccination issue. And that's primarily what we're going to talk about today, although you'll see there are also continuing mask mandates and other safety precautions required. But we're going to be focused on the vaccination issue. The next big event was on September 24th, less than a week ago, when this task force was created. Well, it was created a while back, but they came up with guidance to how to implement the executive order and how to apply it for the government contractors. And that, again, I'm going to cover in some detail right now. Still to come is government contracts are governed by this Federal Acquisition Regulation Council, that they're supposed to make the rules for government contracts. One of the issues about this situation is OMB is acting like they, run the government, and that they can issue rules. And they have stated certain things must be done. And they're dictating to the FAR Council, which is frankly unprecedented. But that too is another problem. Then we have also, as part of the action plan, the direction to OSHA to issue the ETS, and that has not happened yet. I repeat, that has not happened yet. we get calls every day. You know, what are we supposed to do to comply with the OSHA plan? Well, the OSHA has not yet issued its ETS, Emergency Temporary Standard. Now, a lot of this is spelled out, and we're going to have another slide of all ABC resources, but these are two items at the bottom of this slide, which is ABC's own Beltway Blueprint that's available to you all at abc.org. Has a nice summary of the task force guidance, has links, as I've put on the slide here. So you can go right to the guidance. It's not that long. It's written in a very hard to follow fashion, but it is, and they put some FAQs out there. We're going to talk about those. And also Littler, our law firm, has put out its own summary and insights, and we're continually updating that as well. Okay, so in the question about the guidance, was it approved by the director of OMB? That is basically what they assert, and they are asserting that it has been approved by OMB, and that's why they believe it is a rule. It is in effect now, even though they also say that they are directing the FAR Council to issue their rule, and the question remains whether OMB actually has the authority to do what they've done. They clearly believe they have the authority, and they give a cite to something. And, well, we're going to talk a little more about the legal complexities of this. But let's first, because I will tell you, I described different groups that have been contacting ABC. By far the largest group is the group that is saying, what's going on here? How do we comply with it? Somebody explain this to us. So we have the unenviable task of trying to explain very complicated subject for you here now. All right, so let's get to the bottom line. Let's get to what the federal contractor mandate does. And first of all, well, this is as much of a concise summary as I can give you, boiling it down to three things. If you're covered, all the covered employees of covered federal contractors must be fully vaccinated, and they've set this deadline in December by which they want to make sure that is accomplished. Unless the only exemption they're making is for accommodation of disabilities and sincerely held religious beliefs. So if you're following along, you should have the following questions. What's a covered employee? What's a covered federal contractor? What's fully vaccinated? Why in December? And how do we know if we can if we're accommodating a disability or a sincerely held religious belief? We'll try to get to as many of those questions as we can. You also, the contractors, must follow the CDC's guidance, and that's what I alluded to before about mask wearing and physical distancing. Now, this is not new guidance. It's basically the same CDC guidance that's been going for some time that does differentiate between vaccinated and unvaccinated in terms of the extent to which wearing face masks is required and the social distancing that's required and the differences between indoors and outdoors. None of that has changed. They're just saying that you must follow it. And by the way, you may be wondering, but getting ahead of ourselves, what about other state rules that are worse? Spoiler alert on that is if there are state laws that are more burdensome, you're supposed to follow those too. In fact, when in doubt on any of these things, if there are more than one agency coming at you, like the federal contractor and OSHA, or federal and state, you're supposed to do whatever is more burdensome, or in their words, it's to do whatever is more safe. So that's just something to park, and we'll come back to that. Again, there are no size limitations for government contractors. The 100-employee thing that you've heard about a lot, that's only for the OSHA rule. So if you're not a government contractor, or you're sure you're not a federal government contractor, and let's go through that too before you tune out for this first half of the program. If you're not, then you've got to worry about the OSHA over 100-employee standard. If you are not either a federal contractor and you also don't have 100 employees in your workforce, and that's your whole workforce, by the way, not just your tradesmen or people, hourly workers, then if you're not in either category, then you have nothing new to worry about yet. But by the way, federal contractors include subcontractors. So a lot of you are covered, whether or not you have a direct federal contract. So let's get into some more details about this, and it would be wise for you all to stay tuned to make sure you're not included, except that there's also talk that we're going to see copycats from some of the state governments. So even if you manage to get off the hook for this round, you may well find yourself in difficulty on the next round. Oh, and we had a question. It's a problem with us in Washington. We use initials too much. OMB, that's the Office of Management and Budget. And in many respects, they run the federal government. And this is demonstrating more and more over the years how they've taken control, taken power that they didn't used to have. It used to just be an administrative office in which people said, what's OMB, and didn't care. Now they really are exercising authority that many people did not know that they possessed. Okay, so good questions, and I'll keep looking out for them as they come in. All right, so step one for the federal contractors is which employers does the mandate cover? And the one bit of good news, mostly good news, is that this particular mandate applies only to contracts and subcontracts with the federal government. And at the beginning, it looked like, well, for construction, shorthand is if you're covered by the Davis-Bacon Act, then you're covered, because those Davis-Bacon Act clearly does apply to federal contracts. But Davis-Bacon also applies through a number of different so-called related acts. Many of you are doing Davis-Bacon prevailing wage work with federal money on the project, federally assisted contracts. And an issue that we were looking at just this morning and yesterday is it certain that this is only federal contracts with the federal government, or are there other types of Davis-Bacon contracts that are covered? Frankly, the jury is still out on that. There are no FAQs on that, but there's an important part of this guidance that specifically, it does not answer the question in the guidance itself, except that it incorporates a previous rule that just came out earlier this year that some of you may not have even known about, which was to raise the minimum wage for federal contractors up to $15 an hour, only for federal contractors. And they incorporate the definition of federal contracts from that rule in this rule. Okay, and when they did that, the one for the minimum wage on federal contracts is pretty darn specific that it applies only to the federal government. Contracts directly and subcontracts directly with the federal government, not federally assisted. In fact, not even contracts of the District of Columbia, which are part of Davis-Bacon. But do not appear to be covered by that order. And if that one doesn't apply, then it looks like this one doesn't apply. But if I sound like I'm hedging my bets a little bit, well, it's been less than a week to look at this, and I only looked at it about a dozen times. So there's more to be gleaned. I anticipate we'll get an FAQ from the Office Management and Budget, as they have promised they will keep doing things to try to add clarity to this. Now, one other way to tell if you're covered is that it will not apply to you unless the clause that refers to this mandate is inserted in your contract or subcontract. So, and we've had issues under Davis-Bacon where if that clause was not in there, you have a defense of the Davis-Bacon clause. So you could be looking at your contract or your subcontract and see, you're working on a HUD, affordable housing, which is not directly with the federal government. You're working with a private developer. And then you look at it and it says Davis-Bacon is in there. So if you just assume Davis-Bacon applies, you might wrongly believe you are covered by this new federal contractor mandate. The way we are viewing it so far is it does not appear to have that broad a coverage. It's focused on direct federal contracts, which certainly are Davis-Bacon, but they are also with the federal government or on federal lands. Those are the main issues, federal property, or service contracts. So that could apply to maintenance that some of you do. It's not actually construction, and it applies to those also. But again, the common denominator appears to be federal contracts. So that could narrow things down considerably. And if that turns out to be not the case, and they really want to include federally assisted projects, that'll expand it considerably. And by the same token, it does not appear it applies where it's a state contract. Has to be a federal contract, federal government contract. So, I say this until the states start copying this order, and you may find it imposed by certain state governments. And of course, you'll have other state governments that are saying there should be no mandates. We're going to come back to that in a second. So we're just trying to get established which employers this apply to. So federal government contracts, Davis-Bacon typically, or service contract, and federal government, with the incorporation of the language into the contract. And somebody's already asked, does this apply to existing contracts or not? And it does not apply to existing contracts unless and until they hit a renewal or option year, and then it will come in. What they have said is it's going to start for contracts, new contracts or option contracts entered into on or after October 15th, 2021. So that's an important date. And it also confirms that they believe they have the power to do this, because they're not saying if the FAR Council is ready on October 15th. They said this is going in October 15th. And they are strongly encouraging, and this is the other room for slight doubt about the limits on this, is this last bullet point. They're strongly encouraging departments and agencies to impose the requirements on contracts not covered by the order. Now, that what they were really, in that context, they seem to be referring to manufacturing contracts, which are otherwise not covered by Davis-Bacon or the Service Contract Act, but still, very dangerous open-ended statement. What does that mean? They're encouraging them to impose it. If it's not covered by the order, then it's not covered. That would be our position. But they had a listening session yesterday at which the government agents did some talking, and their message seemed to be, we want this to be interpreted as broadly as possible, even if it's not in the executive order. And frankly, that's very dangerous language, and I think there will be pushback against that. All right, well, let's get to which employees are covered. And this, again, is we're still just talking about the federal contractor mandate, though I am shortly going to be turning this over to Brad Hammock to talk about the OSHA standard. So on the federal contractor mandate, it is employees working on or in connection with a covered contract. And this has surprising scope to it. It does capture remote workers, which has surprised a lot of people, because the original concept was they're mandating it for the federal employees, and they wanted to mandate it for contract employees who were in contact with those federal employees. But they've abandoned all pretense on that. They've said anybody working on or in connection with the covered contract, and that means not only remote workers, but your headquarters staff who never go to the project. They're covered if they have anything to do with the contract, the federal contract. So billing, legal, your lawyers may find themselves covered. And what does it mean to be covered? It means they have to be vaccinated. And also, if someone is a subcontractor helping you to provide this, even though they're not at the site, and definitely if they are at the site, all of their employees have to be vaccinated. So you can see how this thing mushrooms. They must be, so those are the employees who are covered. Plus, on top of that, is if they are working at a covered contractor workplace, a new concept, but it's designed to get at the home office, a second way to get at the home office, because they're saying, all right, you got people roaming around the office, of 3 of whom are working on a covered contract, 100 of whom, or 50 more, they're in the same building as the people who are on the covered contract. Even though those people never go to the site of the contract and are not working with any other employees who are at that site, they too are deemed to be covered if they are working in the same location as the other employees who are on the contract. So this is this concept of the covered contractor workplace, which is just another way of broadening this whole exercise. So, there's a whole guidance, particular FAQ, number 11, strongly urge you to read that. It kind of explains it, sort of like what I've got here, but a little more detail, frankly, not much more detail. This time they concede that this alone doesn't catch remote workers who never come to the office. But they also go out of their way. They have another FAQ saying, well, all right, we have people, what if we have people on floor 10 who are doing the government contract, and we tell everybody else to stay off floor 10 so they don't have to be vaccinated? Will that work? And they basically said, only if you keep them out of the elevators, you keep them out of the lunchroom, you basically make sure they have, the parking garage they mentioned, you make sure they have absolutely no contact at your own headquarters workplace. It looks to be extraordinarily difficult. Might work if you have a separate building, but when they say separate, they mean totally separate. So that's likely to be a huge source of controversy. All right, and so what exactly is mandated? Fully vaccinated by December 8th, unless they're exempt, which is the religious and disability. That's it. Then fully vaccinated means 2 weeks after receiving the second dose, not the first, in a 2-dose vaccine, and they mentioned Pfizer or Moderna, and 2 weeks after the single dose of Johnson & Johnson or Janssen. Now, we don't yet have a booster requirement, but by the way, they leave themselves the out, and I'm going to hit this on the next slide. They can update their guidance once you have signed on to a contract after October 15th. They can make changes in it, which again is generally unprecedented, and they don't talk about any change orders either. So that's going to be another concern, but as of now, no requirement that they get the vaccine booster. You are required to collect and maintain proof of the vaccination if you're covered by all this, and you can't rely on just somebody's honor system to say that they did it. And they have a question and answer about what if somebody lost their documentation, so it's in the FAQs. Although it doesn't completely answer the question, but it says contact the health department, contact other people, and but get it is their answer. They also want you to adhere to the CDC masking and social distancing requirements, and then you're supposed to check, this is really to check the CDC county, the tracker website for any changes in the locality for CDC. If you're in a high risk and low risk area, some of the safety protocols are different. It does not affect the vaccination requirement. That is for all areas, whether you're high risk, low risk, or it doesn't matter. You're also a new requirement supposed to designate a person to coordinate COVID-19 workplace responses. Okay, so now one thing you won't see in there, let me go back to it, there's no testing requirement. That's because there's no exemption to include testing. It's not like what is predicted and what you've been hearing about for the OSHA standard that Brad's going to talk about, which says vaccinate, and if you're not, then you have to submit to testing. Here, there's no if. You're either vaccinated with an exemption, or you're either vaccinated, or you have an exemption from vaccination. So the good news and bad news is there's no testing to pay for and no testing to worry about. But for the employees who are not vaccinated, there's no out unless they are disabled or have the religious exemption. So that's an important difference between this and what we expect the OSHA standard to do. All right, the timeline we're talking about, I mentioned October 15th. So it's contracts awarded for awards prior to October 15th. It's only when the option is exercised or an extension. So up until then, you don't have to worry about it. Then we have contracts awarded after November 14th. November 14th, 30 days later, the clause must be included. And then you have contracts in between October 15th and November 14th. They're saying during that window period, they want them to be included, but seem to recognize that they may not be able to get it done in time. But there's this last bullet that I mentioned. They claim the right to be able to make new changes later, and you're going to be stuck with those, they think, when that happens. Okay, let's see. All right, a bunch of FAQs, things that some of you have been asking about, and we'll answer some of your questions after the fact. But they've answered. Here are some of the questions that you all are asking. Things you're supposed to do: covered contractors, you're supposed to post signage. You're not required to provide on-site vaccinations. It's in your interest, of course, to get your employees vaccinated. That's what this is all about. So you do want to take steps, but it's not mandated, because as far as they're concerned, you're going to be off the contract if you don't succeed in getting your employees vaccinated. That's why the burden is all on you. You must review and retain the copy of the vaccination card. Self-attestation is not enough. They also talk about joint employers, but they're focused on joint employers with the contractor and the agency being joint employers. But there's another aspect of joint employer that affects many of you, because you may think you have fewer than 100 employees. You may think that only you are covered, but the staffing agency that you're working with, or the subcontractor, depending on your relationship, you may be responsible as a joint employer. Either way, there is a flow down FAQ that just came out today, as a matter of fact, shortly before we went live. It talks about the general contractor's responsibility to flow down. Apparently, the vision is a general contractor is not responsible to collect the documentation from the subcontractors, but you are required to satisfy yourself that the subcontractor is complying. And it wouldn't surprise me if general contractors or higher tier subs insist on seeing the documentation so they have proof of compliance. No testing requirements imposed. This guidance supersedes any state or local law that purports to prohibit vaccine mandates. There could be a challenge by some governor. We've heard there will be, in fact, but not yet. Okay, and just want to move forward in order to give Brad a chance here. But here's a bunch of questions that are still mostly unanswered, like what are you supposed to do if your employees refuse to get vaccinated? They mostly say, A, that's your problem, but B, don't worry, because we think it's overblown and they really won't all quit. Or that the number who do will be small enough. Easy for them to say. There is a lot of concern that that is going to happen. Who pays for it? Can you have a change order? Well, it'll be a new contract, so it really won't be a change order situation. And to what extent you can factor these kind of costs into your bids is completely left open, actually. Nothing really said about that. How is it going to be enforced? That hasn't been described either. In terms of any penalties, but our state discover lack of compliance, debarment is certainly a possibility. You'll be in breach of the contract, but I'm sure they'll work their way around to penalties as well. And monitoring compliance, they haven't said how they're going to do it. Oh, and by the way, is this whole thing legal? That is very much up in the air, and is something that's being considered, because this is all supposed to be done under the guise of making the government more economical and efficient, and it's hard to see really how it does that. But it does other things, and so it's just something that people are looking at very closely, and ABC is looking at, but no commitment has been made to file a legal challenge as yet about the federal contractor mandate. I think I did touch on this, the other questions, other than the what do we do now part. We'll circle back at the end, other than throwing up your hands. There are things that we recommend. And what action steps ABC is taking, we're going to save that for the end. So let me, with that, turn it over to Brad to talk about the OSHA ETS.
Great. Hey, thank you, Maury. And thanks to obviously everyone for joining. This topic is, front of mind for all employers out there. Obviously, those listening who are government contractors and those mandates apply. It's certainly something that you're dealing with right now. But all employers presumably are going to have to at some point deal with this new OSHA ETS related to vaccines. And so we are going to segue now. And it's funny, Maury ends his slide before turning it over to me with a bunch of questions. Really, with this, all we have is mostly is questions. We have a few different ideas about what's going to be in this. We can guess as to how OSHA is going to structure this, but there are a ton of unknowns right now with respect to what OSHA is going to do here. And so it's fitting that we go from one slide with a bunch of questions to even more questions here with this ETS. But let's start with kind of what we know, okay? What we know here is that in President Biden's Path Out of the Pandemic plan, he is directing OSHA, the Occupational Safety and Health Administration, to promulgate an emergency temporary standard, a rule, that would require all employers with at least 100 employees to ensure the workforce is fully vaccinated or subjected to weekly COVID-19 testing, okay? That's the basics of what this rule is expected to involve. Now, obviously, there are a ton of unanswered questions with that, which we'll talk about. But that is what we know here in terms of what this rule will look like. In addition, as part of this plan, OSHA is required to, for covered employers, again, those with at least 100 employees, to provide employees with paid time off to get vaccinated and recover from side effects associated with the COVID-19 vaccine. Now, one of the things that we'll talk about a little bit later is the phraseology here, recover from side effects, is actually a better way of saying what the path out of the pandemic described as employees who may be, quote, under the weather as a result of getting the vaccine. That's obviously a huge question as to what it means to be a little bit under the weather. So that's one of the areas that OSHA is going to have to fill in. The White House expects that the ETS will apply to over 80 million private sector workers, right? So they are hoping that as a result of that, vaccinations will increase significantly, putting aside the federal government contractor mandate, the CMS, healthcare mandates that are out there as well. This is President Biden's sort of third prong at trying to encourage and get folks vaccinated from COVID-19. So that's the broad sort of framework of what we're dealing with here. Before delving in a little bit more into this and what this rule could look like, I think it's fairly important to kind of talk process. One of the things that questions that I'm getting a lot right now relates to when is this thing going to come out, right? What is the process? What is the timeline? How does this actually work, okay? And I know right after President Biden issued his Path Out of the Pandemic plan, people were worried that OSHA was going to issue this rule, by the following Monday, right? Thursday to Monday. So let's talk about when to actually expect this and then what the process is going to look like putting this thing out. So the first thing is there's no set timeline that's been given. The department has suggested that something will be out within weeks. And so we are just sort of left speculating what that means. Our best guess is that something will come out sometime within the next 6 to 8 weeks. If this slipped up to 12 weeks, I wouldn't be surprised. The reality is, from what we understand, is that OSHA did not have a significant amount of sort of a heads up related to this. So I don't believe they've spent a lot of time in advance preparing what this rule will look like. So I think we're, at least 6 to 8 weeks out, maybe even a little bit longer. OSHA has also stated that it will not be seeking any formal comment or even considering public comment in advance of issuing the ETS. Okay, OSHA, as many of you probably know, issued another ETS a few months ago, and in advance of that, while OSHA not, open a public docket, they did hold some stakeholder meetings. They hold some listening sessions. What we are hearing here is that OSHA is essentially not receiving any comment. They are saying they're on a tight timeline. They appreciate everyone's interest in this issue, but they are, not considering any formal stakeholder feedback or really even informal feedback. I know that a number of groups, a number of construction groups, have reached out and given already sort of unsolicited feedback on issues. That's certainly appropriate, and maybe will have some impact. But OSHA is stating, at least publicly, that it is not going to listen to folks in advance. Now, once the ETS gets issued, right? Once the ETS gets issued, it will become effective essentially very, very quickly. Okay. Now, there may be an opportunities for some litigation and a stay by the court. I'll talk about that in a moment. But as a practical matter, OSHA is going to set a very fast sort of compliance date. If you look at the current healthcare COVID-19 ETS that is out there now, OSHA essentially provided employers 2 weeks to come into compliance, and then 30 days with just a few provisions to come into compliance as well. So this is not a situation where you should expect OSHA issues the ETS, gets published in the Federal Register, and then you're going to have 6 months to come into compliance. OSHA is going to probably have a very high expectation that employers get into compliance with this thing very quickly. And so that should be the expectation for sure. For those of you who are operating in OSHA state plan states, right, not federal OSHA states, you know, the Californias, the Washingtons, the Arizonas, and so forth, what OSHA is expected to do is give them approximately 30 days, or maybe even less, to announce whether they will be adopting the rule, or to justify as to whether the rule is not needed or what they have in place is as effective as the federal OSHA rule will be. I can tell you federal OSHA's expectations will be that states follow this. And so states that are out there, you know, who are potentially objecting to this are going to have to, you know, formally do that and go through that process with OSHA, because, you know, I think federal OSHA's expectation is that folks do this. And then the last thing to point out in terms of timeline, the ETS itself will serve as a proposed rule. So while OSHA is not seeking public comment on this in advance of the ETS, once that is issued, that becomes a proposed rule. And then folks can submit comments on that at that point. OSHA will then have 6 months essentially to review those comments and either make it a permanent rule or to pull it back or take any other sort of final action on it. So there will be an opportunity to formally comment on what OSHA comes out with. Unfortunately, that period will be after publication in the Federal Register and after folks are expected to be in compliance. I mentioned judicial review, and that potentially there's a possibility that this rule could be stayed by the courts. I just wanted to flag this provision in the rule, in the statute. So what could happen here, and again, I get this question a lot from a lot of different folks, you know, is this going to be challenged? What is the likelihood that this challenge will be successful? How does this work? Just to kind of let you know how this happens, once OSHA issues the emergency separation standard, it triggers a judicial review provision that is in the Occupational Safety Health Act. And that's reflected in this slide. Essentially, gives interested parties the ability to challenge the rule with executive promulgation and court of appeals, directly to the Court of Appeals. I suspect there will be a number of groups that are interested in essentially challenging this, both because fundamentally there's some questions about whether there's a great danger that exists, but also, whatever is inside the rule itself. Once those decisions filed, will get all of them sort of consolidated in one circuit and reviewing judicial review. That process, it's important to emphasize, that process does not stay implementation of the rule. So simply filing for judicial review, filing challenge the review in the Court of Appeals does not stay the application. You would have to separately file a motion to stay the rule pending that appeal. Again, it's hard to know what's in this thing. It's hard to know what folks will do. However, obviously, there is also interest potentially in not just filing a legal challenge with review to review the rule, but also filing to stay the rule pending that review. It's not something that happens a lot in OSHA history, but it's certainly something that could happen here. So we need to stay tuned. Obviously, all of this is way premature. We're just dealing with the government contractor mandates. We don't have this rule yet. We don't know what it's going to look like. We don't know how OSHA is going to make some of the decisions, some of the regulatory decisions it does. But so it's really early here, but just keep in mind that there certainly is the ability and the possibility of challenging this once it gets ultimately published. Okay. The next couple slides, I kind of want to talk about some key, what I call unanswered questions, and then some key concerns that folks are having. And, you know, kind of piggybacking off what Maury was doing to lead into this part. There are so many different questions out there with respect to what this rule is going to look like. I think the best guess, right, for how OSHA is going to approach this is for them to kind of go back on what they're comfortable with doing, okay? And that is essentially saying something along the lines of, sort of analytically, okay, what's our hazard here? Our hazard here is essentially unvaccinated people at the work site who could give other people COVID-19, even if they're vaccinated or not, right? So in their view, that's the hazard. It's sort of like this roaming hazard of unvaccinated employees. So the way OSHA is going to say to employers, the way that you deal with this hazard of an unvaccinated employee, is you do one of two things. You mandate that everyone be vaccinated. That's one way to deal with this hazard, right? Because you are vaccinating that unvaccinated person. Or if you want to continue to allow people to be unvaccinated, then you have to make sure they're tested every week, because that's a secondary way to protect workers from the hazard of an unvaccinated employee, right? You test them to make sure that even though they are unvaccinated, they do not have COVID-19 when they enter the work site. So if you think about that in terms of that framework, it helps sort of determine, right, how OSHA might go at this. And I emphasize that is because I don't think OSHA is going to say or mandate to an employer, you have to mandate vaccinations, right? They're basically going to say to an employer, it's your choice, okay? You can mandate, right? And we know that this can happen outside of the OSHA context. We've heard all these different stories of employers mandating vaccines. Or if you don't want to do that to address the hazard, you have to test the unvaccinated folks weekly, okay? Now, that raises one of the first issues, okay? Who would be responsible for paying for and managing the weekly testing? In that framework that I've set out, I think OSHA will say the employer is the one who has to pay for it. That raises a very tricky issue, because if you're an employer out there who doesn't want to otherwise mandate vaccines, right, then you could be potentially on the hook to pay for that weekly testing. I anticipate that is what OSHA will do. We don't know. Another way OSHA could adopt this would be to place some of the burden on employees, right? So if employees come in and decide that they don't want to get vaccinated, well, then maybe they have to produce the negative test result, placing some sort of burden on them. That's not historically how OSHA has proceeded here, but that's also a big possibility. So how OSHA does this will have a significant impact on employers and the cost that employers will need to pay to effectuate the rule. Some other questions that are out there, you know, will employees be able to opt out of testing for any reason, or only for those reasons recognized by other federal law, like the ADA, things that Maury was talking about earlier? You know, it's another good question. I think, again, with the framework that I've laid out, I don't think OSHA will directly deal with that. I think they'll leave that in an employer's hands to sort of manage, right? Either you mandate it or you figure out your weekly testing. Things like kinds of tests, what types of tests will be permitted, what types of documentation will be required, right? Can you do a home test kit? Does it have to be the PCR test? Can it be the rapid test? All of those things, what will be acceptable? I think OSHA's got to iron out. We don't know. What does under the weather mean? I talked about that at the outset, right? Employers have to pay for paid time off to get vaccinated, and as well, if folks are under the weather after receiving the vaccines. What does that mean? Can an employee just on their own say, I still don't feel well? Can that last a week, 2 weeks, 3 weeks? What does that actually look like? Of course, a big thing is, how is OSHA going to define this 100 employee threshold? You know, as a general matter, we have learned that OSHA's approach, at least initially would be to say that 100 employee threshold is company-wide, right? Not worksite wide, not establishment based, right? So if you've got a company and you operate, 50 job sites, and each job site's got, 2 people on it, you're going to be over that 100 employee threshold. That's the way OSHA has typically handled these sorts of situations. There are some other questions that come up, things about franchises and things of that nature, not as necessarily as important to the construction industry, but that will still be something that OSHA's got to factor into this. And I would just say, for those of you, who are familiar with OSHA rules, you'll know, OSHA has never really done that, really never carved out a safety and health standard based on employee count. So this will be new. And then I think the last couple things, obviously, what will the penalties be for noncompliance? Will they be sort of record-keeping type penalties, $2,500, or will OSHA kind of go after folks, $13,000 per violation, or even more? And then finally, one of the big things, at least for the construction industry, and this is one of the things that could sort of gird OSHA's legal challenge, is whether there's really a grave danger throughout all industries necessitating this rule. The construction industry is been determined by OSHA to be a low risk industry. In only a few circumstances has OSHA even suggested that construction work is a medium risk category. So yet OSHA will be saying in this rule that there's a grave danger that exists for all employers over 100 employees that necessitates this rule. That is going to be difficult for them to justify in a court of appeals, and certainly something that folks are watching closely. Finally, some key concerns that I think we all need to be thinking of with respect to an ETS. Again, as I talked about, construction work doesn't pose a great danger, right? So it's a low risk for COVID-19. Transmission rates are not particularly high. Construction is being proactive in general with respect to COVID-19. Why would you be imposing this on us right now, right? We are not facing a grave danger situation warranting the ETS. Obviously, there are big workforce impacts. Obviously, there's a size issue. This will only apply to employers with over 100 employees. But given the types of workforce shortages that I know everyone who's listening to this has experienced, I mean, I know there's almost a webinar a week that ABC is putting on workforce issues. This has the potential to really impact employees, whether they continue to work for you. And so that's something that OSHA's got to think about, and is certainly a potential concern. Resources for vaccines and testing, impact on vaccination rates. We talked about the burden shifting of who is going to be responsible for paying for testing. If it lands on employers, that may not have as large an impact on vaccination rates as if it would if employees were responsible in some way for providing the testing. Paperwork burdens. If you're going to be doing weekly testing and you've got anywhere near a significant number of employees, how are you going to document that? How do you keep that? Those are real burdens that OSHA's got to think about. Cost of paid time off, and particularly with employees that are under the weather. And I guess the last thing that I would note, which is a really significant one, and I know a number of industries have raised these concerns with OSHA informally, is availability of testing. Those of you who are operating in California, you know that they have had certain testing positions for a while based on how outbreak status happens in the state. And it is not easy to get that test done, and it's not always cheap. And so there's a real concern right now that specifically OSHA says, okay, employee workers either get vaccine testing, or you're not going to have that supply. So that's another concern with ETS. That's something that OSHA is considering going forward. This is coming up we're weeks away. Obviously, don't need this President Biden backtracking at this point and say, hey, we don't need this. So you have to be ready for this. We'll continue to work year round. Just so you know, there finally, don't remember, there are still states out there that are very active in this moment. Virginia is issuing orders, California is looking at another temporary stand here as well. So you're reading some of these states Even a lot of states have given authority to their state officers to enforce certain orders under the general duty clause of the states. So look, don't be mindful of that. There's still activity out there. Your opportunity in California in particular. Right now, you need to focus on getting those rules. And this rule will be coming. Remember, there's a comprehensive standard in those places as well. So keep that in mind. So a lot of stuff for folks to focus on. Obviously, the government contract mandate. This company, you got state stuff. Luckily, we'll take people go back to work. They'll take this. ABC is there with a ton of different resources to help you guys do that, which we obviously encourage you to look into.
I've got a question about you can give me a couple that you want to answer. I've got a few minutes here. I'm going to answer a couple that are left over from the first I want to mention, people have been saying what they do doing. And these are some of the actions that ABC has taken to date, most of which have involved making contact with the federal officials at all levels to raise the concerns that we've been raising today and that many of you have been asking questions about on both rules. And I said at the beginning, I said at the middle, but sometimes people dial in the middle. We are talking about two separate rules. So if you dialed in and you heard 100 employees, well, that only applies to the OSHA rule. It does not apply to the government contractor rule. And conversely, the OSHA rule applies whether you've got a government contract or not. Now, let me just see if, we have also a resource slide here. And by the way, I think we mentioned the slides themselves are available. ABC has an excellent COVID update page, has created a vaccine toolkit, and is constantly covering these things in the Newsline publication. And Littler is doing similar things with our resource page. And in fact, the two resource pages are linked. So you got all the information, in fact, more information than you can handle. I'll just mention in closing with some questions, a few that we didn't get to, and we'll try to follow up with a lot of excellent questions that were asked. Send you some emails afterwards. But one that was asked, does it apply everywhere in the United States, including Louisiana? Yes, is the answer. No geographic restriction, except, and I'm talking about the vaccine mandate. It only applies in the United States, does not apply outside the territorial jurisdiction. Someone asked, I made reference to the Davis-Bacon contract language. When you have a contract or subcontract that is covered by the Davis-Bacon Act, or one of the so-called related acts that's expanded Davis-Bacon, you should have a clause in your contract or your subcontract that says exactly that you have to pay the prevailing wages on these Davis-Bacon projects. Now, one thing we've seen over the years, many subcontractors don't get that clause. They don't even know they've been working on a Davis-Bacon project. Hard to believe, but true. And so, if you don't get that clause if you don't get this mandatory vaccination clause after October 15th, because the general contractor wasn't aware of it, didn't include it, you actually may be off the hook. They seem to acknowledge that, and that's also the case in Davis-Bacon situations. But often the subcontractor is wrong. They thought, well, I never heard about it, but you look in the fine print, and it's amazing how small they can make the print in most contracts. It's there, so you better make double sure that is there or not. Someone asked a question about overhead. Are we saying that all the overhead applies? And there's ongoing debate. The clarification, the FAQ, is not specific with any percentage of time spent by different entities like human resources or billing or that sort of thing. If you touch the contract, is that enough or not? And the executive order was not clear. The guidance so far has not been clear, but they do incorporate that minimum wage rule that had some additional guidance and details. Some of it applies. It could apply the same way. Other things like the remote workplace rule, it already looks different the way they're describing it now. So it would be too easy if they made it the same, right? So we can't rely on that, but it is a good question to ask, and we will be tracking that, and I think there will be more FAQs. And then there were a number of questions about the exemptions and the religious disability exemptions. And if they're exempt, can they work? Yes. If they're exempt, then even though they're not vaccinated, they're going to be right there on the project because they're exempt. Now, how do you tell, especially the religious belief exemption? Well, they're both difficult actually to establish, but at least you can get a doctor's note to establish the disability. There's no real, actually no major denomination is actually opposed to vaccinations. So they've come up, the theories that you see out there are not wanting to, because vaccines do something with placenta, fetuses, that they challenge it on that basis. And there have been some recent court decisions rejecting that argument. So the religious exemption is going to be fairly limited, but they don't give detailed guidance other than to say it's your responsibility to figure it out. Subject to second guessing later on, apparently. That's the best watchword we have at the moment. Brad, you got some extra questions?
Yeah, just a couple things before we close up. One couple questions that came in that were wondering whether the OSHA ETS would sort of includes this sort of federal project type language. In other words, essentially wondering if the federal contractor mandate is also a limitation on the OSHA ETS. And the short answer is no. This is not, the OSHA ETS is going to cover all employers, whether you're a government contractor or not. The other thing that comes up, the other couple of questions that came in, and then a lot of them on the number, what constitute 100 employees as we expected. Is it project based? Is it company based? It's most likely not going to be project based. You got one big project in Louisiana, you got 89 workers on that. Okay, but your company has 3 other projects with another 50 workers. You're going to be covered by this. It's not going to be project based. The last question that I'll know, because I think it was a good one, is what do you think OSHA is going to do with temporary workers? Would those count in the 100 employee piece? And I think most likely OSHA will deal with this, and I think probably the answer is yes. Excuse me. I think the answer is yes. I think OSHA will figure out a way to capture those in some way in that 100 employee threshold. So good question. Stay tuned though, because that will be tricky.
I'm going to pick that. I answered the first question. I'm going to answer the last question, which was because I saw it several times. Work is outside. Surely we don't have to be testing people for that. Surely you're wrong. And don't call it surely. So you do, according to this, in fact, they have a specific FAQ about it. Outside, inside, if they're on a federal contract or a covered one. And again, I'm talking about the federal contractor one. Outside, inside, doesn't matter. Vaccination required. I think that's all we have time for today. We see the questions continuing to come in. It's understandable, and we're here to answer them, so we'll do our best to answer them afterwards. And Karen, let me turn it back to you.
Sure, and I would like to just mention, I know Maury put up ABC's resources, what we have currently. One thing I'd really like to encourage everyone to do is on Wednesdays, Newsline goes out. We will continue to provide all updates in Newsline. Things are happening rapidly, as both Maury and Brad said, so please take a look at Newsline. And if you want to look at what happened yesterday, just go to abc.org, and we do have some updates on there regarding both rules. So, well, thank you all for attending. I want to thank both Brad and Maury for a great presentation, which was extremely informative. And I'd also like to thank our strategic partners, CNA, the Contractors Plan, JLG, Milwaukee Tool, Southwire, Tradesman International, and United Rentals. We did get a few questions on how people can get the PowerPoint. The webinar is recorded, and that will be archived on abc.org. And within 24 hours, all participants will be getting an email that includes the link to the webinar recording as well as the presentation. So please be on the lookout for that. Today's webinar is copyright 2021 by ABC with all rights reserved. Thank you all again, and you may now disconnect.